As a full-time neutral, I think one of the things I have to tell people is that technically we don't practice law. I'm a full-time neutral right now with JAMs, doing both mediation and arbitration. And we take kind of like an oath to no longer represent clients, but to practice or to work as a full-time neutral. So when we're hired as a neutral, whether it be a mediator or an arbitrator, we're not technically practicing law. We don't have clients. We're acting in that sort of middle space. Day to day or week to week is always different. There'll be days where I have a mediation, and that could be hybrid, in person, or fully virtual. And it's really different now. It really depends on what the parties want. And in a mediation, we're in there for at least 8 hours because that's what they engage us for. Sometimes they want multiple days. But that full day would be devoted to a mediation. Before the mediation day, they would have submitted mediation statements. So I would have reviewed them, be as up on the case as much as possible, because these lawyers have been with the case for months, or years, and so they know the case really well. And we come in kind of cold later on. So you want to be up on it as much as possible so that they don't have to spend too much time catching you up. But that's what a mediation day looks like. If you have an arbitration, you might have a conference call to begin the arbitration where you meet with counsel on the telephone, and you walk through the logistics of an arbitration. You set the ground rules, discovery deadlines, deposition deadlines, check-in deadlines, and then you have that call, and then you'll put out a scheduling order sometime that week. And then you might not hear from them for a couple months while they go off and do their discovery and depositions. You'll hear from them if they have conflicts that you need to resolve as an arbitrator, but the arbitration process can sort of run without the arbitrator if counsel can work nicely with one another. And so that's another day. Another day might have an arbitration where counsel are fighting about discovery, about items that one side wants produced but the other side does not want to give, so you'll have to make a ruling. So they'll give briefs and you'll read briefs, you'll make a decision and you'll put that down on an order, and then you'll send that out. So that can be another day. As a neutral, we're outside the courtroom. So, the idea is that the parties, for one reason or another, don't want to be in the court. And if I'm in a courtroom, I guess that might be it might be an issue. It might be a problem. I think most people want to be arbitrators because there's a lot of flexibility in your schedule. You're setting your schedule. A lot of the work can be done on your own time, in your own space, wherever you choose to. So there's a lot of discipline that you need to have. I'm still working on it. But I think flexibility is perhaps the most attractive thing. The second thing is that the issues that you work on and the cases that you work on are different. So everything's different. It's challenging. You have cases that come to you that are outside of what you maybe see every day. I've started my career as a neutral, as a mediator in labor and employment, but in private practice, I've done many different things outside of labor and employment, and that sort of is interesting intellectually and challenging, and so it develops you as a lawyer. You have to be on your toes. You have to be aware of new trends that come into the field, and you have to follow them. And so it's intellectually satisfying and challenging and also flexible. So those are, I think, things that attract people to want to become full-time neutral. The challenges is to become a full-time neutral is not an easy path. The general path is to become a judge and then work as a judge. And then afterwards you can become an arbitrator, because that's sort of like a private judge, and then work as a neutral, as a mediator. They're actually two very different skill sets. And so, one has to really know which one you would like, and then to be an effective practicing neutral, to be open to, two different types of work that fall under one umbrella is a challenge. And being a judge has been one traditional path. Going to a law firm, developing substantive expertise, and then, let's say, leaving the law firm after you've been a partner for a while. And that traditionally has been how people, the vast majority, have become neutrals. Otherwise, if you do it by yourself, it's difficult to get people who hire you. That's the key. I mean, if you put up your shingle and you say, I'm a mediator, I'm an arbitrator, you're one when somebody hires you to be one. And that there is no nationwide certification to be such, but it's about business building, about being an entrepreneur. So a lot of people go to law school because they want to be professionals. They just kind of want to do the work hard, but they don't necessarily have, an entrepreneurial bent, which is fine. But if you're going to be a neutral, you're going to need that, because that's the way you get people to hire you to be a mediator or an arbitrator. And that's probably the primary challenge for a lot of people entering the field, is how do I make a living as a full-time mediator or an arbitrator, or both? And there are many paths. You just have to be resilient and know your market. Know the market that's going to hire you, or that you think is going to hire you. And then be prepared for that to be totally off, so that you can change your game plan, and then be resilient and to develop it again. And that's, I think, right now the challenge that I've seen for the last 20 years, and that I continue to see. The field is always changing. So within the next 10 years, it might be totally different. There are increasingly graduate programs in dispute resolution, where people go to law school and then they get an LLM in dispute resolution, and then maybe you can go into government and work as a dispute resolution professional right out of that. That's what I did out of law school, so that was a little bit different 25 years ago when I did that. But as things are, the field is always changing. I was a government major in undergrad and Asian American Studies minor in undergrad. So I was always interested in race and the law and ethnic studies, and sort of how I fit as an Asian American, Chinese American in the society that I found. And so that took me to UCLA Law School in California, where Kimberly Crenshaw was teaching race and the law, and I wanted to continue sort of that sort of focus. And there, Carrie Mankameto was teaching mediation ADR at UCLA when I was there. And I was just kind of following things that I was interested in. I wasn't quite sure, what I would do with that afterwards. But after law school, I found my way to the EEOC in New York City, where I grew up. And the person that I found my way to there was in the mediation unit. And I wasn't particularly interested in mediation, particularly at that time, seen as something that, older people did. My brother was like, why are you going to mediation? Only old people do that. But it was the opportunity that I found access to. And it was at the EEOC where I was very interested in being. Obviously, coming out of law school, I was like, I should go to the litigation unit. I didn't have that opportunity there, but I went with the opportunity that I had. And once I started volunteering there, I found that it fit. It was in my area, and I could be decent at it. And so that was my career path. I worked with the EEOC for almost 15 years, and worked as a mediator for most of that, coming out of law school, which was probably a little unique, but that's how I ended up eventually leaving and going into private practice as a mediator and arbitrator. In addition to the classes, that I mentioned, race and the law, ADR, Working on the Asian Pacific American Law Journal was really rewarding. And, they were kind of in some ways like esoteric. These are the areas I was interested in. But, working in the area of race and the law as an Asian American was something that I was interested in. And when I came back here, it really, I think, came in handy. I could, give into my community. I could work with a broader civil rights community. It was the right place. By following the things that you're interested in, it'll take you to places perhaps you hadn't imagined. But you shouldn't be afraid to just go forward with the opportunities that you meet, because you don't always have everything open to you. But you go with the opportunities that present themselves, and then you build your skills and you make the most of them. And that's what I did, and it's served me well. I would say develop substantive skills in the area of law that interest you, and then become well regarded in that field. And you can become well regarded by developing niche expertise, where you as a young lawyer coming out can become an expert on AI, generative AI, things that older lawyers will have very little expertise on, NIL, name, image, likeness. Sort of look at what's hot, because the law is always changing, because the law reflects and, governs society. So you look at what's hot, you're young, you're a digital native, you grew up in these worlds, the world's about to change completely. So develop substantive expertise, because if you want to become a neutral, a mediator, an arbitrator, you'll do that at the end. When you become an expert, people know you, and then when they say, well, we need to find the mediator or an arbitrator, and that, it's that person. Because they read an article you wrote, they've worked with you on something. That's, I think, the way I would say to approach it, because it's difficult to come out and just say, I'm a mediator or arbitrator, just hire me. That's, I think, a very, very steep challenge. So develop that substantive expertise, which means you might not work in ADR right away, but you can always sort of do things on the side as a volunteer or on the side to keep that sort of fire burning while you develop your expertise substantively.